Hello everyone, my name is Nicole Gervais, and today I'll be discussing a scenario involving the disclosure of patient information following a court order or authorization. First, I'll start with some background information regarding our scenario. Our scenario takes place at Montgomery City Hospital with an ambulatory care facility. It's a pretty large facility consisting of 10 multidisciplinary physicians, 3 mid-level providers, and a large support staff. Additionally, the hospital has a few specialty departments, including mental health care, radiology, a laboratory, and nutritional services. Currently, the hospital is transitioning from paper charts to electronic health records, or EHRs. Due to the hybrid nature of the charting, certain pieces of patient information are stored in various ways, including paper records, scanned, handwritten documents or notes, EHR notes, and various electronic systems that provide lab results and physician orders. For our scenario, we are assisting the Director of Health Information Management, who is the hospital's health records custodian. Currently, they are having trouble responding to subpoenas for patient records because there is no documented process on how to procure patient records. Because of the hybrid nature of the patient charts and lack of protocols or guidelines, the task is time-consuming and inconsistent. For this assignment, we are tasked with creating a streamlined process on handling these types of requests. So prior to receiving any subpoenas, we'll need to determine what is considered part of the patient record. We'll need to determine if items like patient emails or insurance correspondences or financial notes are part of the patient record. Once we have that defined, we'll need to determine what information is legally protected from disclosure. Some of these items may include drug and alcohol treatment, psychiatric and mental health treatment, HIV/AIDS status, as well as the presence and treatment of certain STDs and communicable diseases, additionally genetic information and adoption information. It should also be noted that there may be certain additional privacy protections for minors regarding the treatment of drug and alcohol misuses, as well as HIV/AIDS and STD treatments. Once we've established that these guidelines, we can begin to process these subpoenas. So once we've received a subpoena, we'll need to review the information included in the authorization. It is important to determine if the request is valid by checking for signatures and authorizations, by also reviewing any photo identification if appropriate in that situation. Next, we'll determine what information is being requested. If this information is not specific or the request is unclear, it should be returned to the person who is providing the authorization or request. Otherwise, the staff member should call the court who issued the subpoena to ask any questions or clarify or validate the request. Additionally, in civil cases, if the release of patient information is deemed unnecessary or inappropriate, the hospital can reject or object to the subpoena. Next, we'll have to determine what and if any patient information should be protected, but it should also be noted that if the subpoena or case relates to criminal charges relating to this protected information, the patient information must be provided. An example of this would be a criminal case involving an HIV-positive patient who knowingly infected another individual. So at this point, we've reviewed the subpoena and determined its validity and what information should be included. At this point, we'll be ready to start gathering the patient information. First, we'll start by determining when the patient began receiving services from the hospital. This will help us determine if the patient was seen prior to the transition to EHRs. If they were established prior to this transition, they will probably have a paper chart somewhere in the organization. And if they became established after this transition, they will likely have an electronic record. After this has been determined, we'll need to start or request any patient charts relating to this patient. These could be stored in the facility somewhere in the hospital or with a file clerk or off-site at a storage facility. Once the location of the chart is determined, charts should be requested to the HIM department. Next, we'll need to determine what types of services the patient receives, so then we can then determine where the patient information might be stored. If they had any types of procedures done, it's likely that the patient has paper consent stored somewhere. If they had any laboratory tests done, then they probably will have information stored in electronic systems that store this type of information or these reports. If the patient was admitted to the hospital, they will likely have nursing notes that were scanned into their chart. And lastly, if they had any doctor visits, there are likely transcribed EHR notes from those visits in their record. Once we've brainstormed and determined where the patient might have information stored, we'll need to start gathering those documents. From the request or authorization, we'll need to determine if the original copies are needed or if copies will suffice. Next, we'll produce the requested information in accordance with the guidelines we determined earlier. It's important to provide only what is specifically being requested and withholding protected information or any information that's not pertinent to what is being requested. We'll need to determine if there is a fee for providing copies of the chart. And lastly, we'll need to ensure that the procurement of the requested information is provided within any necessary or appropriate timelines. Next, I have a few recommendations for processing subpoenas and authorizations. When providing patient information, the healthcare organization should include some type of notice explaining that the organization has disclosed only the information that has been requested, and any protected information or information not included in the request has specifically been excluded from this disclosure. Secondly, if there are any specific organizational policies regarding the disclosure of patient records, this should also be included in that notice or the packet that's being handed over. An example of this would be a healthcare organization that chooses not to include patient records that were provided to them from another provider. And lastly, if there is any doubt regarding the validity, specificity, or legality of a request, the hospital and HIM department should consult with their legal team just to clear up any of those confusions or doubts. So in the state of Maine, there is a law, Title 22, Section 1711C codifies the disclosure of patient information. In the statute, the security, privacy, and confidentiality of patient information is protected. It outlines the process of disclosing patient information, including who may access it, and also specifically address requests made by court orders or by a subpoena. It's important that healthcare organizations outline the process of releasing patient information, including the release of information to legal entities for the sake of our patients. It's imperative that healthcare organizations ensure the protection of patient information as well as the privacy and confidentiality of that information. The foundation of patient care heavily relies on trust and vulnerability, and so it's incredibly important to protect that information and keep patients safe from any unauthorized disclosures of their information. It's also very important that healthcare organizations are in compliance with any legal requirements or upholding any applicable laws. And then to summarize the information presented, I've created a flowchart for staff members to reference when processing a subpoena or authorization request. It starts with creating guidelines on what information is included in a patient record, what information is protected, reviewing court orders and subpoenas for validity and specificity, determining where patients may have information stored, gathering that information, protecting any information from not being requested, or any information that's not being requested or legally protected, and then processing the request by producing the documents, collecting any fees, and documenting that the disclosure occurred. So I believe the following guideline or flowchart, like the one I've created here, will help any HIM department appropriately process subpoenas and will help clear up any confusion and will encourage standardization in processing these requests. And so that is my presentation on processing subpoenas and releasing patient information. And thank you for listening to my presentation.